on the tape.
Did you hear Jack? Is Jack here?
Yes, I'm here. Thanks.
Oh, good. I didn't hear you. Come on.
Okay. And so Commissioner Levinson, Jana is starting the recording, so we can go on the record whenever you're ready.
Great, thank you so much. Good morning, everybody.
Good morning.
For the record, the special meeting of the Washington State Public Disclosure Commission for the purpose of holding a hearing regarding reporting modification requests. Today's April 2nd, 2018. Time's approximately 10 a.m., and I'm Ann Levinson, Chair of the Commission. Let me ask my colleagues to go ahead and introduce themselves for the record.
This is Jack Johnson, Vice Chair.
David Ames, member.
This is Bill Downing, member.
And the staff?
Peter LaValle, Executive Director.
Jennifer Hansen, Filer Assistant Specialist, presenting the request today.
Jana Greer, Administrative Officer and Executive Assistant to the Commission.
Great. And our legal counsel?
Scott Douglas, Assistant Attorney General.
Terrific. Is there anyone else present at the Commission office?
There is no one else present, Commissioner Levinson.
Thank you. So we'll be conducting this meeting pursuant to RCW 3405, which is the Administrative Procedure Act, RCW 4217A, which is our Campaign Disclosure Contribution Law, and WAC 390, which includes our Public Disclosure Commission rules. The meeting is being audio taped. Commissioners are all participating by phone, and the PDC staff are present at the PDC office in Olympia. So for today's agenda, we're going to be addressing what are referred to as F1 reports, or reports of financial affairs and gifts. RCW 4217A 710 describes what must be reported, and under 4217A 120 and WAC 390-28 040, a filer may apply for a suspension or modification of one or more of those requirements. The applicant must file with the Commission a written request for a hearing for suspension or modification of these reporting requirements, and then may choose to waive personal appearance at the hearing and submit instead a written sworn statement setting out in detail the rationale for the request of the modification or suspension. As I understand it, all applicants have waived their appearance today. Is that right, Jennifer?
Mm-hmm. That is correct.
All right. So the Commission will hear these requests and then may vote to either suspend or modify any of the reporting requirements if it finds that a literal application of the law works a manifestly unreasonable hardship and the suspension or modification will not frustrate the purposes of the law. New requests and those where the request for renewal of initial requests was granted more than 3 years previously, or if the applicant is holding a different office or position, must be heard by the full Commission. So we have 5 requests for reporting modifications today, four new ones and 1 renewal. For purposes of judicial economy, we'll hear all of these requests in this single hearing, and then a separate order will be issued for each. Ms. Hansen, if you would state your name for the record, raise your right hand, I'll swear you in, and then have you present the requested modifications. Do you swear or affirm under penalty of perjury that the information you'll be providing today in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Do you want to go ahead and present these based on the type of modification, and then the commissioners can decide whether they want to address them individually or by group?
Madam Chair, today, because there was only 1 renewal, I went ahead and provided them in alphabetical order by new requests. I believe that it is these have historically been heard individually when they are new and only heard as a group when they are renewals. Would you like to go with that historical preference, or would you like to change your process today?
Let's go ahead. The first one is a different basis than the second, third, or fourth. So let's hear the first one individually, and then I'll ask the commissioners how they'd like to proceed.
Thank you very much. The first request is from Anita Crawford Willis. She is a judge with the municipal court judge in the Seattle Municipal Court, She is requesting a modification to not disclose all of the detailed information regarding the location, including residential address and plat description or legal description for her personal residence. She indicates that the only information provided regarding her request is that she believes it would cause a manifestly unreasonable hardship to have her residential address or plat location disclosed because it would endanger her and her family's safety. She has disclosed per the requirement under the rule. She's disclosed the required creditor information, payment terms, security given, and mortgage amounts for her residence.
Okay, thank you. Let me say for the record that I've worked with Judge Crawford Willis, but don't believe that working relationship would impact my ability to be fair and impartial. Do any other commissioners have any disclosure with regard to any of the applicants today that we need to get on the record?
This is Commissioner Ammons. I have a long-time friendship with Dave Zeke, who is asking for a modification, but do not feel it would hinder my ability to be impartial.
Okay.
And I guess I would say the same. I know Dave as well from the News Tribune.
Okay. And then we have reviewed materials. We've been provided materials for each of these requests. Jennifer, is there anything else that was not provided, any other information for the record today for any of these applicants that was not already provided?
The only additional information that was provided that the Commission has not had an opportunity to review is the last applicant on the agenda, Bruce Dammeier, provided an amendment to his F1 to include some information on a supplement page. It does not have any bearing on his request today. It was just additional information that he failed to disclose initially or didn't have all the complete information when he filed earlier this month. So the request that you have in front of you for Mr. Dammeier is complete in order for you to be able to assess the modification request and to determine if there was a renewal or not.
All right. Thank you. So
Can I ask a question of Jennifer? When a person submits a request such as these, is there any discussion that takes place, any feedback from the commission staff? And I guess I'm asking specifically about Judge Crawford Willis. It seems to me that it would be best to point out to her when the submission comes in that the commission, in order to grant a modification, has to find that there is clear and convincing evidence to support the request. And she, I think, neglected to submit any specific facts that would support a finding that either she or a family member had been threatened, or that there was an outstanding no contact order, or there was some other presently existing similar personal safety concern. Maybe she has something and neglected to include it, or maybe not. Is there any clarifying request given to the applicant?
So thank you, Commissioner Downing. There was not any additional discussion with any of these applicants at this time. There is, I thank you for noting again your concerns about the test of the modification request not being included in the written materials that are provided to the Commission. There has historically been discussion with applicants at different levels. Myself being the only staff member at this time that is reviewing these requests, I did not make any additional follow-up with any of the applicants, including Judge Crawford Willis, regarding her request. I have provided the information to the Commission as she provided it to me. I have discussed with other staff here at the PDC the possibility of changing this process a bit. We're currently going through some process improvement in order to change this, and I believe that your comments in particular should be included in that process improvement, and that some additional follow-up should be done at some level. So, but for these requests that you're hearing today, none of that follow-up has been done.
And,
Okay.
and Commissioner Downing, at the last meeting, we had a similar discussion, and particularly for these judicial requests, had suggested that the staff, upon initial review, if it appeared that there was not yet sufficient articulable facts, do reach out to the applicant to let them know that more information would likely be needed as a preferable approach to setting it, and then if the commission decides not to grant it, then having to go back and having an additional delay. So that would be consistent with what we've discussed before, and really is dependent on staff capacity and the number of requests that come in.
Well, am I correct in reading 4217A120 as requiring that the commission find clear and convincing proof of the findings required?
That's
under the
correct.
sanction?
Yep.
Okay, right.
And the form itself specifically says that you explain in detail, and that it be based on, quote, tangible evidence or a specific threat, not just because of the office held.
Right.
I had the same concern myself, Judge, when I looked at this application. I wonder if maybe we could hold this one over and have the staff reach out to her and explain that the requirement the showing of tangible evidence or specific threat.
I would support that.
Commissioner Johnson?
I just wondered if that was a motion from Commissioner Ammons, or
Yes, I'd be happy to make it in the form of a motion. I move that the commission defer action on Judge Crawford Willis's application, and that staff work with her to have specificity of any tangible evidence or specific threat that she has received.
I would second that.
It's been moved and seconded for discussion. I do have some thoughts about that, but I would defer to others first in terms of the request.
this is Jack. I have to agree with the sense of the comments from the other two commissioners. It's just on its face, there isn't enough here to support granting it, and if she has a case for this modification, she needs to give us more to work with than this. I've had a probably low threshold for being convinced in the case of judges, but there has to be something to work with, and there really isn't here. So I agree with the motion and the sense that the other two commissioners have expressed.
So what I'd like just to make sure we're being clear with the staff in terms of our the articulable facts that we'd be looking for with regard to judicial officers. I concur completely with the comments made that there are not in this application articulable facts, but in terms of what she would have to provide, we have in the past said that our standard for clear and convincing proof for this subsection would not be that a threat has already occurred or that harm has already occurred, and then someone would have to go back and request, in essence, a retroactive exemption. That if they could articulate, given the position they hold, the cases they hear, and what's been in front of them, or enough of articulable facts that we believe there is a potential threat to their safety, and it doesn't frustrate the purposes of the law for that exemption just of the residents, that we can make that finding. So I'd just like to hear from the commissioners if that's what you're asking of the staff, or are you asking that work with the applicant to verify that a threat has occurred?
Well, this is Commissioner Downing. I'm not looking to change the way things have been done always. I just think we need to recognize the language of the statute. I believe there is a purpose to the chapter. I believe there is a purpose to allowing public awareness of financial interests that a judge might hold, because it may impact rulings that judge makes. So I think that there is a purpose, and that purpose can be frustrated by suppressing that information. The statute requires that we make some finding by clear and convincing proof in order to outweigh that interest. If there is nothing at all stated, then it's simply impossible for us to make that finding. So I think it is just important that there be something there stated. Okay. And again, I don't dispute the way it's been handled in the past as far as potential threats, and not necessarily requiring an actual threat or an actual no contact order.
All right.
But they need to make the best case they can make.
All right. Commissioner Ammons?
It's difficult on the phone conversation, but I don't disagree with Commissioner Levinson's thought on and Jack's comment on having a fairly low bar. But if that is the continuing approach that we're taking, then I think we need to, at the very least, change the form, which requires the applicant to show, quote, the phrase based upon tangible evidence or a specific threat. That is not sort of a theoretical threat, or just because your caseload includes a number of bad actors and has for a variety of time been that way. But I feel like it's hard to sort of create a policy that contravenes the clear language.
Right, and that's the needle I'm trying to thread for us here in terms of the request of the staff to follow up. I think we all agree that this application doesn't present sufficient articulable facts for a modification, and the level of information that we'd like to make sure staff obtain. So we're asking staff to get us to both change the form and to request that filers present a set of facts that substantiate the concern about their safety should their address be provided. But we're not asking staff to provide proof that such a threat has already occurred.
Well, I'm not sure we're not, because it says based upon tangible evidence or a specific threat, not just the subjunctive.
Well, this is Commissioner Johnson. I guess historically the Commission has been relatively sympathetic to the risks that people in law enforcement and the judicial system face as a reality, and that those threats can be articulated even if there isn't a particular threat. The inherent threat that comes with many of these positions, I think we've been willing to consider in supporting these things, but I think we'd be hard pressed here to articulate how much proof we need in order to approve one of these things. And I'll just note that the Commission has supported legislation that says that people in this kind of position should be more categorically exempt from this. But without making a substantial deviation from our policies and practices of the past, communicating to applicants that they need to take the best shot they can at explaining why it is they're concerned and based on what is about the best that I would be able to tell an applicant.
Right. Okay, any other feedback or comments on this before we vote? So just to repeat for clarity of the record, it was moved by Commissioner Ammons and it was seconded by Commissioner Downing, is that correct?
Yes.
Yeah, that we direct the staff to contact the applicant and ask her to provide additional information that would support this requested modification. And we'll defer action at this point. Is that a fair summary?
Yes.
I think so.
Okay. All right. All those in favor, please indicate by saying aye.
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 Any opposed? Any abstentions? All right. That motion passes. Jennifer, you want to go ahead with the other? Let's go ahead just at this point individually. We only have 3 of them.
Okay. Thank you. The next applicant is Gregory Sandstrom. He is the current county coroner in Kitsap County. He is requesting a modification that would exempt him from disclosing the business customers of a business that his spouse is 100% owner of. The business is West Sound Workforce. It's a temporary staffing business located in Gig Harbor, which is in the area where Mr. Sandstrom serves. The request is being made because Mr. Sandstrom indicates that it is the business West Sound Workforce is operates in a competitive industry, and that publishing the reportable business customers would put the business at a competitive disadvantage. He has confirmed through his report that he submitted for the public, the financial affairs statement, that Kitsap County itself has done no business with West Sound Workforce. In addition, he's disclosed reportable governmental customers, so he's only requesting to not disclose the business customers.
All right. Are there questions for staff, or is there a motion on this one?
Could we batch the 3 that are in front of us right now on business-related modifications?
We certainly
I think
can.
they're all fairly clear and fairly similar in a lot of ways, in that it would be manifestly a manifest hardship to list out all of the client information, and so I would propose that we approve all. Or do you want to wait and have any kind of recitation of the other 2?
Yeah, let's if you'd like to entertain a single motion, I'm fine with that, but we need to have all 3 presented first.
Yes, I move that all 3 requests for reporting modification be granted as that we grant a partial reporting modification as requested on the basis that literal application would cause a manifestly unreasonable hardship on the applicants, and that a limited modification would not frustrate the purposes of the Act.
So I'm going to ask folks to hold on that just for a second, because we still need to hear the presentation from staff on the other 2, and then we can entertain that motion. We'll hear them. Okay. Go ahead, Jennifer.
So the next request that Commissioner Ammons has included in his preliminary motion is a modification from Douglas Shea. He is the current prosecuting attorney in Chelan County. His request is similar. However, he's asking for a modification related to his own business, not that of his spouse. And then the final applicant is David Zeke, who is a newly appointed trustee of the University of Washington. He is requesting a modification related to a business that to a law firm that his spouse is a member of.
Okay.
I'll second Commissioner Hammond's motion.
All right, and any further discussion or questions for staff?
I just a small question on David Zeke's application. My recollection is that UW, they're called regents and not trustees. I realize you use the word trustees. Do you know, Jack, if that is so, that they're still called regents?
Yeah, they sure are. I decided that was it was close enough, but you're quite right on that. That's actually the title.
Great. The flagship universities are regents, and the others are trustees.
Mm-hmm.
The other 4 years.
Mm-hmm. Any other questions for staff? All right, it's been moved and seconded that the Commission grant the partial reporting modifications for these three as requested on the basis that literal application of the law would cause a manifestly unreasonable hardship on the applicants and that a limited modification would not frustrate the purposes of the Act. All those in favor, please indicate by saying aye.
Aye.
Any opposed? Any abstentions? All right, that motion passes. And the request for the renewal?
The final request is Bruce Danmeyer. He is requesting a renewal of a modification granted in the past. As Commissioner Levinson mentioned at the beginning of this meeting, his is being heard today at the full commission hearing because it has been more than 3 years since his last modification request, and he has changed offices since that last request was reviewed and approved. That was approved in April of 2015. His request is the same as it has been in the past, requesting a renewal of business customers for a business that he is an owner of.
Okay. Are there questions for staff on this one? All right, is there a motion?
I move we approve renewal of this modification request on the basis that literal application of the law would cause an unreasonable hardship to the applicant and that granting it would not frustrate the purposes of the Act.
Is there a second?
Second motion.
All right, it's been moved by Commissioner Johnson, seconded by Commissioner Ammons, that we grant this request on the grounds articulated. All those in favor, please indicate by saying aye.
Aye.
Any opposed? Any abstentions? All right, that motion carries. With regard to the first matter, I think we should also ask of the staff that they do that in such a fashion that we can then go ahead and hear that at the April Commission meeting, that request.
Sure.
Yes,
And then,
I will go forward with that process, commissioners, and request that additional information be provided by the applicant so it can be presented to the full commission at the April meeting.
Thank you. And then in just looking at our rule, at our WAC, the form does set a higher bar than our WAC actually articulates and that the statute articulates. So we definitely do want to align the language in the materials we provide requesters with what's laid out in WAC there.
I agree
Okay.
with that.
All right. Are there any other matters to come before us today?
I have nothing. I'm looking around at the other staff that are here in the Olympia office. It looks like no one else has any additional information to provide today.
Okay. Commissioners, anything else from any of you?
Nope.
Nothing.
All right. Well, thank you very much, everybody. We will adjourn this special meeting, and we'll talk to everybody soon.
Thank you.
Thank you.
Thank you very much.